Morning, please be seated. This is the time set for oral argument in Florence against State of Arizona, our cause number 1CA CV130476. Counsel, I know you've all been here before. You're aware that we've conferenced the case and are familiar with the briefs and the record. You're also aware that we're being video recorded. Each side has 20 minutes, and let me stop there and ask if there is any division of time we should be aware of.
Yes, good morning, Your Honor. I've been asked to inform the court that ordinarily in a case like this involving an intervener, the Attorney General's office would argue first, but because the Superior Court granted Florence Copper's motion, we've agreed that I will argue first on behalf of appellees on the condition that I leave Mr. Husstand 10 minutes. So that is our plan.
So 10 and 10, okay. And
on my side, Your Honor, I'm going to argue for all three of the appellants, and I do intend to reserve rebuttal time.
And you're free to do so. You can reserve as much or as little as you wish, but when the clock says 0, that's the end. Okay? With that, we can begin.
May it please the court. The trial court committed reversible error when it granted the intervener's motion to dismiss. The crux of the issue is that the appellants have pled a sufficient cause of action. ADQ, we allege, is regulating outside of its statutory authority. Instead of denying the motion, which this court should do on de novo review, and therefore reverse, because that's what the effect would be of this same motion being before this court, the trial court ultimately reached a final result on the merits. But the court did so without a developed record, without foundation, and ultimately reached, with all candor and due respect to the trial court, an erroneous conclusion as a matter of law. Therefore, what our prayer is before this court is that you reverse and remand so that we can turn to the next chapter, which is after the complaint is filed. The reason that the motion to dismiss needed to be denied, and it was a very clear and obvious decision, and why this court therefore has a clear and obvious decision to reverse, is that the complaint states a well-recognized cause of action under Arizona law. The complaint seeks declaratory relief under the Administrative Procedures Act. ARS 41-1034 A and B says parties that are either affected or may be affected by a rule or affected by an agency practice, which we allege in both subparts, can file a complaint for declaratory relief, which is exactly what we did. And what we're alleging is that ADEQ, through this rule allowing a temporary aquifer protection permit, is regulating without authority, meaning they are going outside of what the legislature carefully prescribed to them. The standard is to look only to the complaint. The court, as it knows, must assume the truth of all well-pled fact allegations.
Well, let's stop there. Let's stop with the difference between factual allegations and conclusions of law. It's true that there's a right of action. There's no question about that. But you also have to have then, when you're challenging the validity of a regulation, a legal basis. And we don't have to accept your legal basis as true. Neither did the trial court. You'd agree with that, right?
Right. But
okay. So what facts did the trial court miss?
The facts that the court missed is, as implemented, ADEQ through this rule is ignoring the clear requirements that the legislature prescribed for individual apps. Within Article 3 of Chapter 2, ARS 241 through 244 is expressly directed to individual aquifer protection permits, whether they be of long or short or temporary duration. And what we've alleged, which will require development of a factual record, which we've been deprived of, is to show that as they have created this rule and as they are implementing it, they are excusing certain requirements that the legislature absolutely imposed.
Which ones? Because I poured through the brief, and basically the message I got, tell me if I read it wrong, but the message I got was the statute is silent as to these temporary permits, and therefore they're not allowed. But I didn't see a direct conflict between something the department has created by way of this regulation and a statutory command?
Well, for example, we know that under ARS 241 through 244, there has to be adherence to what's called bad cat. Under 244, there has to be very clear adherence to properly drawn pollution management areas and locations of points of compliance. They cannot be excused in the name that because this is a temporary permit and therefore these projects are going to be small scale because the ostensible purpose is to gather data to support a commercial permit one day, that therefore we don't have to be as rigid as the legislature requires. I submit to this court that if we go outside the complaint, we will develop a factual record that shows that ADEQ in practice, which is under 411034B, is doing just that. They are not holding applicants to the specific requirements within 241 through 244. There is a lot of things that a permit must have. And while the answer to the court's question is, do they have the discretion to have a temporary permit rule? Of course they do. But that discretion can only be that any permit that is dubbed an individual permit must comply with every requirement that is applicable to an individual permit.
But isn't that the distinction between the temporary permit and the anticipated permanent permit that would be obtained once the information from the temporary permit was obtained and applied?
Absolutely not. It's an individual permit, so it must be judged as a standalone permit.
What if there's insufficient data to allow the department to conclude whether a permit should be granted or not? Can it not create a regulation that allows it to investigate through actual evidence rather than speculation in an application?
Well, that would be the actual substance of what goes on in an administrative hearing. And although it's outside the record, we've had such a hearing in this case. We're kind of going back to the future with this appeal just due to the time lag of that.
I understand, and there was an issue as to an as-applied challenge versus a facial challenge, and I think it's pretty clear that you had an as-applied challenge, but you had to go to that hearing. So now the question only is whether the regulation is valid on its face as contravening some provision of the statute. And so you've got this bad cat concern. What other provisions of a statute does the regulation violate?
Well, and again, one of the guiding principles when you deal with this particular scheme is that all statutes should be construed in pari materia with each other. So, for example, we know there needs to be a public comment period before a permit is issued. It has to be meaningful, and the public needs to be able to address ADEQ before they issue such a permit. This statute puts the public comment period in reverse order. There's no statutory authority for that. It just puts it behind. So that means that the public, when they first get a chance to tell ADEQ, this is a bad permit in a specific case, this is dangerous, this will pollute the drinking water supplies in certain areas, ADEQ's already made up its mind. That violates the statutory scheme. And so again, when we're judging just our complaint, do we have the ability to go and develop a factual record? If a motion to dismiss is granted, that means that this court would have to declare, on its face, you can't challenge this. ADEQ has discretion.
Well, this court would have to look at the statute and determine the scope of the delegation of authority to an agency and determine whether the agency violated a statute. That sounds like a question of law.
Well, except for one thing. The issue is not just a facial challenge. We have alleged, as implemented and applied to these types of permits, individual permits, which are a subset of permits under Article 3.
Okay, but then doesn't that run you into your exhaustion issue, as far as this case is concerned?
No, because the exhaustion issue is going to get into the nuts and bolts of going through the many detailed subparts of all of these statutes, 241 through 244. Again, outside the record here, we had a 34-day evidentiary hearing over 2 months before the Office of Administrative Hearings. There's a recommended finding. Again, outside the purpose of this motion.
I understand, but the fact that there is another proceeding pending or perhaps concluded does suggest that there was a forum for the development of the factual record that you're talking about. The forum may not have been this action.
That issue, though, needed to be confronted after the denial of the motion to dismiss. When our complaint was filed, it was filed in September of 2012. The fact that the hearing occurred in 2014 on the administrative side is because both tracks proceeded on parallel tracks but independent of each other. We're here to look at the motion to dismiss. It should not have been granted. A lot of the questions that this court has already asked me will go to issues that are better raised at summary judgment, better raised when there's a meaningful record factually. Because again, it's not just the facial challenge of Regulation A210, but it is an allegation factually that ADEQ is administering this temporary individual app program in violation of statutes that are mandatory decrees from our legislature. And when we allege that, we have to have the opportunity to develop it. We have to have an opportunity where a court looks to the next pleading, which is a state's verified answer, where the court then looks at what ADEQ witnesses would say, how are you implementing or not?
Okay, I'm sorry. I don't mean to be dense, but how is the argument that you just made different from the issues that were submitted to the ALJ?
Well, the difference is that, and I'm not, they certainly, there is some overlap.
Okay.
But again, the issue that was submitted to the ALJ occurs way down the road, and it is done on a very specific hearing focusing on this permit and this alone. When we filed our declaratory action, and what we still maintain here, why it is still relevant as we sit here today, is because we sought declaratory relief that a temporary individual app must comply with all legal requirements as any other individual app, and that we allege facts that the director of ADEQ and the staff of ADEQ were issuing temporary individual apps that were not following all of the requirements. We needed the opportunity to develop that record. And as we sit here today, everything seems to have a rhetorical component because our complaint was dismissed. If I was here on summary judgment, we'd be getting into the nuts and bolts. But to just look at A210 and say on its face that they have the discretion, that narrows the issue too much, because what it's saying is, does ADEQ, by virtue of legislative decree, have the ability to have a short duration individual app? The answer to that is yes, but that is not the issue. The issue is, are they using temporary apps to get around the legal requirements? Are they doing something outside of what the legislature circumscribes to them? And that's the crux of our complaint. That's the declaratory relief we're seeking, and we are entitled to develop that and have our day in court. And that's why motions to dismiss should almost always be denied, because you have to get to the next day. You have to see, well, what is the state's answer and response? What did the state's witnesses say? There has to be a developed record. That's why when the phrase shall is used, shall means shall. What the trial court did was it found, well, shall in this context means maybe. No, it doesn't. And I'll tell you, the other thing that was
But
very
shall even though there's several provisions of Article 3 that don't apply, and you admit that they don't apply, right?
Well, now let's be, and I appreciate the court's question, because as we call that is a red herring. In the scheme, ARS 241 through 49241 through 252, you have basically four categories of permits that allow you to discharge into the ground. Individual apps, general apps, exempted apps where you're exempted from some requirements, and emergency waivers, okay? The Enabling Act applies to all. And our point is that when you're talking about an individual app, that any rule that you enact has to comply with the statutes that apply to individual apps. There is no such thing as one permit that you would call, we're issuing an individual general exempted waiver app. And I don't mean that with any disrespect. What I'm saying is that's the red herring argument, is that you have to, if they're going to issue an individual app, regardless of the duration, it has to comply with those specific statutes that are within Article 3 that apply to individual apps. And it is plain, it is unambiguous, it is clear, which is why it is improper to go to a Chevron deference analysis, because you never reach that. And what's equally improper, when the trial court cited to 104A, which is a general statement that this is what DEQ does, that protects our aquifers, among other things in the environment, you also citing to 203A5, 203A5 is completely off point. 203A5 by its express terms applies to underground injection control permits. The state has never issued or implemented an underground injection control permit under state law. That's why the EPA has to issue underground injection control permits for the same type of discharge activity. And then the third statute that the trial court cited, 242A, is just a general subset within the individual apps. The enabling statute, by its very express language, is 203A4, because it says shall. All permits shall comply with these statutes, and it cites them expressly, 241 to 252. Because I want to be conscious of the time, I'm going to reserve time for rebuttal unless the court has any other questions right now. Obviously, when I get back up, I'm going to be reiterating our position that this ruling by the trial court needs to be reversed. Thank you.
Good morning, Your Honors. May it please the Court, Thomas Hudson on behalf of the appellee Florence Copper. At bottom, Your Honors, the issue in this case is whether the court should find invalid a nearly 14-year-old regulation because ADEQ lacked the authority when it promulgated it in 2001, notwithstanding that, one, there's no suggestion at all in this case that ADEQ failed to fully comply with the Administrative Procedures Act when it promulgated the rule. Two, the very criticism that's being lodged against ADEQ in this case was raised and rejected by the agency during the rulemaking process. And three, during the nearly 14 years this regulation has been in effect, the legislature has multiple times amended the statutes pursuant to which the regulation was promulgated while leaving the regulation intact. And bottom line, Judge Swan, you are exactly right. The only issue that is and can be before this court is whether the agency exceeded its rulemaking authority when it promulgated the A210 regulation. And how do we answer that question? We look at the statutes and the regulations.
I know you have limited time, so let me jump right to it. Talk to me about bad cat and public comment as perhaps suggesting conflict between the statute and A210.
Okay. So with respect to bad...
Only two direct conflicts that I've heard mentioned.
Okay, absolutely. So again, to analyze whether there's a conflict between the statute and the regulations, we look at the statute and the regulations. And when you do that, and this goes to the bad cat issue, Judge Swan, what you see is in the statutes themselves, there is nothing that specifies how long an individual permit may be. It doesn't say that there can only be one kind of individual aquifer protection permit. It leaves the length of those permits to the discretion of the agency. So then we look at the regulations themselves. And what you see is there is one individual aquifer protection permit program, and there's merely two types of lengths of individual APPs. Temporary APPs are merely of a shorter duration. There's nothing, and I looked repeatedly, there's nothing in the regulations that says an individual APP need not comply with any of the aquifer protecting statutes or the statutes that the legislature intended.
Was there a public comment period?
When the rule was promulgated?
I'm
talking about bad cat.
For bad cat.
So there's nothing in terms of there's nothing in the regulations that say when you issue a temp APP ADQ, you can ignore the 241 through 243. It's not there. The same statutes apply to both. And then the other exception we've heard is the public comment exception. So how do we analyze that? Well, what we need to do there too is look at the statute that tells the agency what to do with respect to public comments. That's 49-208. And what that says is the agency shall adopt public comment procedure to assure, quote, adequate public participation. That's the language that the statute uses. Then you go to the regulation, and the regulation by its terms includes a public comment period and expressly permits ADQ to revoke a temp APP as soon as having that public comment period, which occurs 30 days after its issuance. So again, you're not going to see any conflict. There's no conflict between assure public adequate participation, which is a broad delegation of authority to the agency. There's no conflict between that and the 8210 regulation. So then the only other thing we've heard, and I guess just to put a button on this point about what the issue is in this case, the statute, it was a declaratory action for declaratory relief, and the statute identified in count 1 was 41-1034C, which is that an agency shall not make a rule under a specific grant of rulemaking authority that exceeds the subject matters listed. That's the standard. Clearly, there's no violation of that statute in this case. So then we've heard sort of some general discussion about, we need discovery, and what I keep hearing is that there's some theory, no specific facts, but there's some theory that if discovery ensues, they might uncover that in connection with issuing some particular permits, ADEQ failed to comply with the applicable regulations or statutes. Well, that's precisely the type of challenge that must proceed through an agency action. That's not a kind of action that can be brought under 41-1034C or 41-1030. Let me just check my notes here. On the public comment question as well, let me note that too went through the rulemaking process. Of course, the entire A210 regulation went through the rulemaking process, and that provision was in there when ADEQ promulgated it. There was no suggestion at the time of the rulemaking that the public comment provisions in A210 failed to provide the public adequate participation in the public comment process. There's no suggestion that that public comment provision failed to comply with 49-208. And again, we know that the legislature has repeatedly amended the statutes pursuant to which this regulatory scheme was promulgated and left that subpart of A210 intact as well. So,
as far as rights of action go, let's say that I forget which brief it was that characterized the substance here as lemon juice, but let's indulge that for a moment and say that the lemon juice actually demonstrably violated some provision of either the regulation or the statute. I'd like to do it both ways. Is there a right, hypothetically, I know this is not our case, but is there a right, hypothetically, for a plaintiff to come in and simply seek an immediate injunction because it seeks to demonstrate that there is a chemical incompatibility between a validly promulgated regulation or statute and the purpose for which the permit is issued?
So to maybe sort of really crystallize it, suppose there's a statute or a regulation that says thou shalt not pour lemon juice on the ground, and ADQ issues a permit that says you may pour lemon juice on the ground.
The distillation.
So, in fact, Judge Swan, what happened in this case is the plaintiffs did seek injunctive relief, which ultimately became moot because this permit wasn't going to become effective until a bunch of other stuff happened anyway. But Florence Copper's position, and you may want to ask Mr. Hestan as well, that you can seek an action for declaratory relief, and you could file an action that says and let's say it's done pursuant to a rule that authorized that would be in excess of the statutory authority delegated to the agency. And if that's true, certainly a court could issue an injunction sort of to see the process through. I don't think there'd be anything that limits the Superior Court's power.
You would contend that that case needs to be submitted first to administrative process?
Yeah, I think it would need to be tied to a particular rule. So I think in our case,
this is my hypothetical is much clearer and simpler than the real world. But if the regulation says, and I'm just focusing on the regulation, not the statute now. Right. If the regulation says no lemon juice and the permit says lemon juice, does court have jurisdiction, or is that administrative?
Yeah. So let me back up on that. If it's simply a conflict between the regulation and the permit versus the regulation and a statute, then I think that does go first to the agency.
Really? So even if there's going to be serious and irreparable harm because the lemon juice turns out to, let's say it's radioactive lemon juice now.
Yeah.
No court can step in and issue a TRO to prevent radioactive
Yeah,
lemon
it
juice?
may. It wouldn't be an action. It wouldn't be the kind of action that was filed here, which is seeking a declaration that the regulation exceeded the rulemaking authority. I think a Superior Court.
Or something?
Yeah, Superior
Okay.
Court has general, sort of general jurisdiction if there were a case in controversy or some irreparable harm. The truth is, I don't know the answer to that question, but I can't imagine a Superior Court wouldn't have jurisdiction to issue at least a temporary restraining order
To stay it
pending
the outcome
pending
of
the
the-
outcome of the agency action. Yeah, something like that.
Okay.
Okay. Unless the court has further questions, I'll just ask the court to affirm.
Thank you very much.
Okay, thank you.
May it please the court. My name is John Heston, an Assistant Arizona Attorney General on behalf of ADQ. Before I start with my prepared statement, if I could turn to the questions the court has been asking. The first question had to do with BAGCAT. BAGCAT is best available demonstrated control technology. In ADQ's regs, they have a substantive policy statement, which is BAGCAT for mining. They also have BAGCAT for sewers and BAGCAT for other types of discharges that may take place. In this particular case, it is a mine. The temporary aquifer protection permit that is at hand here, as with any life of facility aquifer protection permit that would be issued, is subject to BAGCAT. In this particular case, the 42-page permit, temporary permit that was issued, has pages and pages dealing with BAGCAT. Temporary permits are subject to BAGCAT in the same way that permanent individual permits are subject to BAGCAT. There is no
Let's say,
difference.
I'm just guessing here that Mr. Crown might disagree with that statement. If he does, what's the forum for the resolution of that argument?
That would be the administrative appeal. In this particular case, it's one set by statute to the Water Quality Appeals Board, who then has the authority to delegate to the Office of Administrative Hearing. So there is a precise procedure set up for anyone who has an interest. And it's a very broad standard on what gives you standing to appeal. Basically, you have standing to appeal if you filed a written objection during the public comment period. Now, that leads into the second question, the public comment period. Now, the public comment period is based on ARS 49208, public participation. This is a statute that deals with all water programs that ADQ does, not just aquifer protection permits. And it says the director shall prescribe procedures to assure adequate public participation in proceedings of the department. It does not say when the public participation has to take place. And in the case
Is it
of
fair to say that the way this was structured, the public comment was put to the back so that the decision would be made before the public ever had any input on it?
No, it is not fair to say that, Your Honor, because in this particular case, first you go to the permit itself. And right in the body of the permit, it says this permit will not become effective, i.e., you can't discharge, until all three of events have occurred. Public participation has been completed and there is no appeal, or public participation has been completed, an appeal has been taken to the Water Quality Appeals Board, and it is concluded, or all the permittee has indicated that they can now proceed with the permit. Basically, that means they've gotten their Environmental Protection Agency permit that they also need for this project. So within the permit itself, it very clearly says this permit cannot go into effect until after public participation and after any appeal following that public participation. In this case, while the ADQ rule requires 30 days of public participation, they gave almost 90. They received over 15,000 pages of documents in the public participation process. They had dozens of people testify at the public hearing. They issued a 300-page response to all of the comments that were received during the public participation process. They issued another amendment to the temporary permit, incorporating changes from that public participation process, and it is the other amendment that was the subject of the appeal. Now, the appellants have said that they're entitled to their day in court. Yes, they've had 34 days, not in court, but in an administrative proceeding, with all of the challenges that they're talking about, including Bad Cat. Now, if the court has no other questions on this area, I'll move back to my prepared. And in 1986, the legislature created the Arizona Department of Water Resources. In the same year, they gave them general authority to formulate policies, plans, and programs to protect the environment, and then they gave them a number of specific charges. One of the specific charges was they were to adopt, by rule, an aquifer protection permit program. And that same statute said that the program shall be prescribed by Article 3 of this chapter. Article 3 is the aquifer protection article, and it's 49-241 to 49-252. There is no disagreement, as far as ADEQ is concerned, that the rules shall incorporate all applicable provisions of those statutes. As the court has noted, some are not applicable because they deal with general permits. The statutes dealing with individual permits are applicable to individual permits, whether or not they are permanent or temporary. There's nothing in the permit program that the legislature authorized that says ADQ only has the authority to authorize permits for one duration of time or two durations of time. Under the program, they have general permits that are applicable to anybody who does a particular type of discharging. It's the process, the facilities are all basically the same and they have standard rules. Those permits are 3, 5, and 7 years. They could have been 2, 4, and 6 years. Now you have the individual permits. Individual permits are individualized. They have provisions in the permit that set out what specifically that entity has to do, what processes it has to follow, the mechanisms that it may use to do it, the type of monitoring that they have to do. They're specialized for those individual permits. Now, the individual permits come in two time limits. One, what they call a life of facility permit. I call it a permanent permit. It's basically for as long as you're operating under the permit, and then for any post-closure time that has to be done. So in actuality, if your operation is 25 years, the permit might still be open for another 25 years while you're doing post-closure. But it's life of a facility. Now, ADQ could have said 25 years and renew. They could have said 15 years and renew. Temporary permit. If people don't like the word temporary, call it a 1 year with a 1 year renewable permit. It's a term, a length that they clearly are authorized under the statute when they develop a program to determine how long the permit should be in order to be effective. As I stated, individual aquifer protection permits, whether they are life of facility or temporary, are subject to all of the applicable provisions of Articles 1 and 2 of the Aquifer Protection Permit Program and all of the applicable statutes dealing with individual permits. Now, they are individualized. The type of monitoring that might be required in the case of a sewage treatment facility may be different than the type of monitoring that would be required in an in situ mine. But monitoring is required in all of them. And so the individualization is, you have to monitor in this way, you have to monitor in that way. Now, in the complaint, contrary to what the appellants are trying to do now, in their complaint, they make it very clear that they were arguing that there was no statutory authority to issue a temporary individual aquifer protection permit under ARS 49251, the temporary emergency waiver statute, or 49250, the exemption statute, and that ADQ's temporary individual permit rule exceeded the scope of statutory authority granted by those two statutes. Well, contrary to their allegations, the temporary emergency waiver statute is not only not authority for the temporary rule, it has nothing to do with the temporary rule. It provides that if there's an emergency, then ADQ can temporarily waive the requirement to get a permit. If you've got a permit, the requirement to comply with the permit. They can waive the requirement to comply with the surface and aquifer water quality standards. The director can go, oops, we got a crisis here. I'm going to waive all of these exemptions, and I can do it for 90 days while you get everything fixed. In the case of a temporary individual permit, there is no waiver of anything. Obviously, they are not waiving the requirement to get a permit because the rule says in order to discharge, you have to receive a permit. They're not waiving anything.
Understand. I think we're out of time.
Very good. Thank you, sir.
Thank you.
May it please the court. This is a notice pleading state. Our complaint absolutely established a claim for which relief can be granted. As we listen,
Your complaint, it seems to me, defines two claims. One, the regulation is just invalid. It did violence to the statute. Two, whatever DEQ is doing in this case, or generally with this regulation, you think is wrong. With regard to Category 2, you have a forum. It's not this case. It may someday be Superior Court. It may someday be this court, but it's not this case number. And with regard to the other claim that that the regulation is flatly invalid, you're in the right court, but then isn't that a legal question?
well, again, it's mixed. As implemented, a practice is beyond the scope of an individual administrative hearing on an individual permit. We are alleging that not just facially invalid, but as implemented in practice, that is exactly proper for this court to issue, for there to be declaratory relief in the Superior Court at this time. And we are also seeking two claims for relief. One is the declaratory relief, and two, injunctive relief.
Well, the remedy, I think the remedy is a little different than the question of whether you have a valid theory that could get you to a remedy, right?
Well, no, I think that it is appropriate. Obviously, we believe that it was appropriate to seek declaratory relief and enjoin any permit and any practice that is not complying fully with the mandatory statutory requirements. And that's what was, I thought, remarkably overwhelming in our favor. As I listened to both FCI and ADQ's argument, they are talking outside the record. There's absolutely no foundation for Mr. Heston's argument. He's enlightened the court on things that, as you said, I'm sure Mr. Cron will disagree with you. I do. I disagree with most of what he said. But neither he nor I should be debating that here today in evaluating a motion to dismiss.
And nor need we. The real question, it seems to me that your most serious disagreement is over the scope of the jurisdiction of the board or the Office of Administrative Hearings.
Well, this court asked, and we talked about the public comment period. If I look at Regulation A210, D1, if the director issues a temporary permit, the director shall postpone the public participation requirements under R18-9-109. That violates the law. A meaningful public comment period is got to come before the permit issue. That's why the public has the right to address the director before they issue the permit.
Violates the law because you interpret 49208 as saying that public comment has to come first.
Yes, and that's what the statute says.
Okay, but that's illegal.
Regulation.
Back up. If it says issues, does that mean if it's signed on that day? What if the permit has in it language that says the public comment period shall be as follows, as just laid out by Mr. Heston? I understand that's not in the record, but what does it mean to issue the permit? Now,
Well, they issue a permit.
effective?
They say it's effective, but then the regulation says, but we're going to delay effective dates. And what we're seeking is that that's discretion that is outside the scope of legislative authority. When they issue a permit, if for an individual APP, it
has to be effective immediately.
I didn't say that. What I said was it has to comply with the regulations. This court has asked me about public comment. We've talked about bad cat. If you look at 243, there's a whole series of requirements that cannot be excused. They are from how the discharge facility is designed, how bad cat must be applied, how...
So does the regulation exclude these requirements, or is it your contention that ADEQ didn't follow them in considering this case?
It is our contention that both on its face and in implementation, which would be developed by the full record, as we allege in our notice pleading complaint, that they are issuing temporary permits and they are excusing and not requiring permits to meet all the statutory requirements, which therefore, in effect, is giving unlawful exemptions and waivers. We're not saying that they've expressly said we're going to issue temporary permits as waivers or exemptions. We're saying, in effect, it's a waiver and an exemption. And there's far more. Pollutant management areas, POCs. If in this temporary app, they are excusing very strict requirements, and they're doing it as a practice across the board. The apply to this permit, that is for the administrative hearing. But what they can't do is they can't go into an administrative hearing and say, we're ADQ, we have discretion to do things our way. And that's the fault of what the trial court did. It just, in a most general way, went to the end result on the merits, on a motion to dismiss, and said, they've got the discretion to have temporary permits, we're done with the inquiry. And that can't be. There has to be a judicial forum in the Superior Court so that they're not allowed to just come into an administrative hearing on individual permit and saying, we're the state, it's business as usual, and we've got discretion. No, you don't. Because the only discretion you have is to act within what the legislature has told you you must do. And yes, shall means shall. This is not some clever, let's apply Chevron deference and let's find that shall in some rare circumstances means maybe or maybe not. It means shall. And that's...
On that note, I think we're out of time. Okay.
Thank you very much.
Thank you very much. Thanks to all counsel for your arguments. The matter is now under advisement. We will issue a written decision in due course and stand in recess to allow our final argument to set up. Thank you.